Ashwini Dubey has joined us live, AOR Supreme Court. Ashwini Dubey, stringent sections have been slapped. I'm sure you've seen the FIR contents. Are they enough, or are more stringent sections needed? Should this now become an example case, Ashwini Dubey?
If Uday, it is in time-bound manner, if trial is taken to the logical end, then of course. If trial is not taken to the logical end and it is struggling in the court to get the final decision, then this will also die. The usually more media highlighted cases are dying its own death. Now the question here is not only the dowry death; it is where an independence of the women, where she wanted to be the independent for the survival of her child and also wanted to run a business. And that was compromised. Number two, the constitution says the freedom and equality. That equality was curtailed. Number three, what would happen tomorrow? I'm not going to jump on the conclusion, but keeping in view the prima facie evidences, it appears that she was subjected to cruelty, the extreme cruelty, and that led to the death. And I think 304B would have been one offense, now section 80 of BNS, but section 103 subclause 1 talks about the murder where the punishment is stringent, more than the dowry death. And 1031 has been invoked, 115 subsection 2 punishment for voluntary causing hurt, 61 subsection 2 conspiracy to commit serious offense and where all the family members are allegedly involved into it. But as a defense counsel or as a lawyer, I would say what the judgment would arise tomorrow, that would depend on to next circumstances, what evidences court considers and what not. But here the cruelty, if we see, the murder, if we see, that is extreme, because death has been caused by giving bodily injury and put in acid, not within the 7 years of marriage, but yes, within the matrimonial house. And soon before the marriage is here not applicable, as people are talking about that it is more than 7 years of marriage, therefore the dowry death is not applicable. The court strictly did not say that after the 7 years dowry death cannot be invoked. That can be invoked, but that depends upon the circumstances. But yes, this is extreme case where a lady has been burnt alive with the other co-conspirators, mother-in-law, father-in-law, brother-in-law, and witnessed by a small child. That cannot be overruled even by the prosecution, and that benefit should not be given to the defense. But yes, three stages are there in a criminal case. One is the suspect, accused, and finally the convict or acquittal stage, that after the trial is concluded. And keeping in view the today's circumstances and evidences, circumstantial evidence, direct evidence, indirect evidence, it is a case, of course, for conviction. Let's see what will happen. But I would urge to the prosecuting authorities that this must set an example so that no other lady should burn alive inside her matrimonial house. And it's a serious issue where independence
Absolutely.
of the...
No.